behalf of Andhra Chamber of Commerce Telangana State Chapter, Law Mintage Dispute Resolution Hub LLP, we extend our warm welcome to this interactive session on mediation, an effective dispute resolution tool for MSMEs and corporates.
Friends, disputes and conflicts offer so many challenges to each and everyone in this business corporate world. By choosing mediation, companies can lower their legal costs, protect their reputation, and focus on what they are to be done. So mediation is a very effective tool for a wide range of disputes like employment issues, contractual issues, or the customer complaints or IP issues. Sometimes there are some IP issues, so no, this is not related to this and that. And also real estate and partnership issues, shareholders, clients, consumers, all this. So corporates generally come across these kind of issues and we end up wasting our time on those. And mediation can also work alongside other way through arbitration or litigation to create a blended approach that fits the needs of both the parties. I'm sure that today our esteemed speakers will explore the mediation process in more details.
When we speak of mediation, usually a sense of I know it prevails in us. It is not as simple we think of mediation in our day-to-day life. It is indeed been pursued more professionally, more scientifically. Initially, we all know that from childhood we might have learned the all-time renowned mediator, the universal mediator, Lord Sri Krishna. We know the story and the consequence of mediation. The same thing was adopted when we civilized as a small hamlets to a nation. I have seen honorable judges sitting on a vacation bench from morning 10:30 to night 2 o'clock. They did everything to reach out, but the volumes of differences have grown every day to an unexpected heaps. Thereafter comes this arbitration. What difference it makes, in simple words? What we had a public fight, we brought it to private. Instead of a honorable judge, appointed honorable judge, we are having a selected arbitrator. What is the similarity is this: we have a choice of selecting a arbitrator, but still both the arenas we are doing the same job. We are trying to point out who is wrong, who is right. So when you are pointing out to others and trying to make out their flaws, then obviously it is a war, isn't it? In this scenario, the same intellectuals, the same lawmakers sat together to find out a way which could be of much ease, much acceptable, and very steadfast solution finding method. That's when the lawmakers got the idea of mediation. Arbitrator is an authority. Mediator is a facilitator. That's the difference between these two processes. The success of mediation, even before the Mediation Act was floated, is the best example. What I can give is Reliance. I think you all remember when the great Ambani passed away. His two eyes, his two sons, had a conflict, holding the chairman and the vice chairman position, holding the helm of affairs of the business. Did they go to court? It's almost billions of dollars at stake. They didn't go to court. One man mediated their conflict and seen to it that none of their investors' money is wasted in resolving the issues. That's the power of mediation. In court case, in an arbitration matter, you are there to show who is wrong. In contrary, in mediation, you are not there to show who is wrong. You are there to show what is your interest. Mediation is something where you voluntarily come out and the mediator will simply remove your cause of conflict. That is, it could be your ego, it could be your financial circumstances for the moment, it could be third party influence, it could be like procedural issue also. Something you wanted your vendor to do and your vendor failed and you hell bent on teaching a lesson to your vendor. So that is what the mediation says. In mediation, this has been specifically covered that no bias, no partisanship, no opinionating, no judgment. A mediator will be sitting with the both conflicting parties, give them an idea of looking at the issue. He'll change the dimension. Technically, to enlighten, mediation is an attempt. And finally, when you enter into the settlement agreement, the final thing, you can either sign it or you may refuse to sign it. You're going to lose nothing. And the act mandates that whatever you have said in the mediation, whatever you have shown in the mediation, that cannot be used against you. That's the reason that's the best thing for the next generation, I can say. From now on onwards, I'm sure you will, once you understand the power of mediation and the benefits of mediation, the first thing you would opt is go for a mediation.
I'm not here to talk much about what mediation will help the corporates. My focus is need of institutional mediation. Now, before that, I'll try to address what is institutional mediation. Institutional mediation is they help the process to run as per the mandate. They suggest the mediator as to what could have been done better, what issues have been missed by oversight or for any other reason, and how things can be improved. This is the focus when an institution enters into mediation. Meaning to say, Dispute Resolution Hub helps you to act as a bridge between mediation process and what is expected by the litigant in solving the issue. How do we do it? We have a process which is similar to a courtroom, which records the entire proceedings of mediation, and we help you by something called a secretarial service. Means someone says, I know this is the dispute, I'm not able to put it in words, I know what is the amount I'm supposed to get, I have my advocate, but I want a second opinion on it. This second opinion is something called a secretarial service, where we'll explore the entire claim which is made before us. We will see what are the issues, what are the prayers made. We will also suggest this conflict, these aspects are covered, these are not covered, so we can list them as issues while discussion. Now, during discussion, there is a recording and there is a next date given. During today's mediation discussion, we will estimate and evaluate that these issues are solved or negotiated. These are the issues which are pending. We will prioritize the rest of the issues and see that the process of per issue being discussed by the parties is recorded, documented, and confidentially held by the Institutional Mediation Center. By this, parties know what has happened. Issues will not become redundant and repetitive. Effective mediation is implemented. Now, there is a summary given at the end of each mediation proceeding that has happened. Now, this summary will tell you whether the mediation is sailing or it is collapsing. So, each mediation sitting will have a mediator, parties, recordings happening simultaneously. Now, there would be some evaluation here. In between the entire mediation process, I feel as a litigating party that mediator has become one-sided. It is human. We'll feel. If the feeling is strong and factual, we have a system of changing the mediator. Now, this is not done abrupt. This is done in due discussion with the current mediator, with the upcoming proposed mediator, Or we will say, let's not have a single mediator, we'll have 2 or 3 mediators added, and then we'll solve the entire process. Now, there could be another type of issue that crops up. The mediator which is mediating our concern is not subject equipped. I am into hotel industry. Mediator does not have hotel knowledge. But technically, mediator understands that to settle the issue or to negotiate the issue, you need negotiation skills, not hotel industry expertise. Right? But the hotel industry experts, they feel, no, it's not happening. So we try to add another mediator who has a hotel expertise, who can suggest the process and see that the process gets concluded faster. This is the first time where the parties are allowed to present the case in mediation. And you are not talking to the other party, you are actually talking to the mediator. Imagine what happens. You vent out your anger on the mediator, not on the party, because party is on the other side. So the biggest challenge mediator has is to absorb that vent out anger. Have cool and presence of mind. That is where training comes into play. Then identify where the real issue lies. They list it out and then say, in today's 2.5 hours of discussion, 2 minutes is relevant. That 2 minutes is on this issue. This is where you are there. This is where you are there. This is the loss to both of you. This is the profit to both of you. If this is presented, then the mediation process is concluded. This is where our dispute resolution hub comes into play. We see that this process is executed stage-wise in a systematic and a documented, recorded way. Now, the second question which any person who comes to us and says, I want to go for mediation, I am giving you so much of information. The feeling is, they give us certified copies of their property. So what is asked is protection of those documents first. Second, what is asked is guarantee that these documents will not be misused. Mediation, whatever is given, it is not an evidence, it is an information. Information can never go against you, evidence can go against you. So this information, the purpose of that information being collected is to comprehensively understand the issue. It is not to fix you. And this evidence is always stored upon your request. When you withdraw, the documents and the request is also given back to you. But this proceeding, whenever we have something called a pre-litigation of cases, so whenever there is a PLC called for, the judge would ask what happened in pre-litigation. In a general scenario of panchayat discussion, there will be one small paper which says so-and-so conducted the issue, so-and-so parties attended, so-and-so were witnesses, result is nothing happened. There is no description also here. Now in our case, we'll give you a complete proceeding and say there were 10 hearings that have happened. In this 10 hearings, this was the summary of the hearings. The total proceeding was successful or a failure. This is the discussion. So the judge tomorrow knows if it goes into litigation, what are the areas of concentration they have to work out. Our focus is to increase the burden on the judiciary. The reason being, the number of cases that are filed, the number of cases for which judges are given time to, and the number of cases for which expedition is happening is much, much lesser than the number of cases that are filed. We try to expedite and solve 10 cases, 10,000 cases are filed. When will the process happen? And if there is an order is coming, one of the person don't like the order. And if it is a check bounce case, both the parties don't like the order. That is a beauty. The person who has got the or complainant gets the check bounce case in their favor, there is a conviction. Person who has, the complainant who has won the case goes to the court and says, I am not happy with the judgment. The judge should have given him 6 months of punishment. The judge should give thrice the amount of check. Judge did not do it right, hence I am appealing. Person who is convicted anyhow will appeal because he needs bail. they go again, and it continues. A simple check bounce case, we have seen cases where there is no evidence that the person gave money, but still they fight for about 5 years. In 5 years, there is some judgment, and the judgment is appealed, further appealed. Finally, they are in the courts. If this comes to mediation, that's the reason now it is a summary trial case, where every check bounce you go try in for mediation first. If it is a genuine thing, you have money, when you have paid something, where is your focus? Principal or interest or both? Guess. Genuinely it is principal first. First my money should come. If possible, interest. If my fortune is great, damages. If my fortune is extraordinary, I'll get something which I'll not imagine. Many people don't find this fact that no check bounce case gives you money. Fear of conviction leads to settlement. But if the person is convinced on conviction, it's over. It's only appeals that run. You will not get your money. Now this point, if it is driven, then the commercial disputes will not knock the doors of the court. For two reasons. When you have systematically understood your issue, the conflict gets collapsed, egos get subsided, reality check is given, relationship continues. This is the focus when we say an institutional mediation enters. And if you have a doubt in the person who is mediating, you can ask, we will facilitate and see that this person who is trying to mediate does it more effectively. And when there is a record as to what conversations were there, how the conversations led, whether the conversations were actually driven in the form of mediation, because we have a record, we can tell you that this has been done right, this where it has went wrong, now we'll try to rectify in the next hearing. This facility is what we are trying to give to the chambers also. So we'll work together with the chamber to see that things move forward well and positive for you. Thank you for listening.
Hope is a naively denying the problem. Hope against hope. But it is just a relentless believing in the existence of solution. There is a solution for that. There is a hope for us. So similarly in mediation also, the hope is that the matter will be amicably settled to the satisfaction of both the parties. That's very important. When the judiciary was getting clogged with overburden due to heavy pendency, this alternative channels to drain out some of the cases was thought out. One of my chief justices used to say, you may be having 5,000 cases on your board. Yes, we agree. As a Chief Justice, I know you are having a 5,000 case on your board. But what about the litigant? The litigant said this is only my one case. And even in the Consumer Commission, the law mandates 6 months, 90 days, 1 year. It's practically impossible. And naturally, when the agitating public demand, we have to cut a sorry figure. As a matter of fact, in Consumer Commission, I had to openly confess that I am unable to raise up to the expectations of the statute. These advocates will not leave us. They will carry us up to Supreme Court also, and they will, completely try to smash our orders. They will point even from full stops and commas also. They will dig out. That is because they have got remedies. They are fighting for their clients, and there is a just requirement for them. Otherwise, they will be unethical on their part if they won't fight for their clients. And one more thing. Both the parties before the court knows the truth. They know the truth. They are only trying to see whether the judge can make out the truth out of it or not. So it is said, the judge is on trial. The judge is on trial, not the parties. For example, just I'm telling you, husband and wife know what is really wrong with them. The reasons which are placed before us are not all relevant. The real facts are hidden, and that they want us to dig out. So there is a real problem. And another thing is, even the law commission reports are there, Shashi, I think you know, Shanti, that for 1 million population, there should be 50 judges minimum. There's a requirement. We are having sanction strength of only 21. Out of that 21, 30% at a given point of time are vacant. That means about 15 or 16 judges are to cater to the litigation of more than 10 lakhs population. And with due respect, even the Supreme Court nowadays is spending a lot of time on hearing bail applications. I should not comment, but as a judge, I can say bail application ki on the Supreme Court judges are spending so much time. Nothing, no loss for a judge. Our time is not our time. Our time is your time. If I waste my 10 minutes outside, it is not I am who is losing. It is the client who is losing. The sufferers are the public. So our time is not our time. We are not the masters of our time. We are the slaves of the time. We are only here to help the people. For that, our time is very important. So let us save the time of the judiciary. How best you can contribute to that is in your hands. You can do a lot of things to save the valuable time of the judiciary, whereby they can really concentrate on the matters which really needs to be adjudicated. And to overcome all this, mediation is one of the best methods. I can give one example. While I was district judge near Machilipatnam, two sisters, they're twins, they were fighting for a partition. And a lot of rancor, a lot of shouting, courtlo chinnapadalla, a lot of shouting they used to shout. Both are sisters. I slowly suggested, Amma, see, both of you have shared that small space in the womb. Why do you fight for this land when you have shared the small space in the womb of your mother? You have shared the milk. What more you want? After all, for this land you are fighting and you are accusing the sister. I don't know, brother, I should not boast myself, but that did miracle. So instead of wasting the manpower, money, on all those things on this cumbersome and time-consuming litigation, mediation is the most appropriate place where you can place all your cards before the table. Only thing is, a matured person, an experienced person who knows the real human values should be made to mediate. While I was chairman of the State Commission for Consumer Disputes, this Apple phones. 3 brothers from Begum Bazaar brought those 3 phones at the cost of 83,000 each in those days. They were not working properly. They went to service center at Secunderabad, Patni. And they were going there. That engineer used to say, you leave behind the phone and come tomorrow. They were not, they came, we won't leave the phone. We will be here only. You check the phone before us. And the big company, they were saying, no, we won't do. You leave the phone and go, come tomorrow. So the litigation was going on. Even when I tried to call the engineer and said, Babu, why don't you check the phone before them and tell them, no, sir, we won't do it. It's against our policy. Sorry, sir, we can't do that. Let them leave the phone, we'll do it. Then I gave him churka. I said, all right, brother, if you won't do that, I will pass an adverse order against you. And tomorrow I will give it to all the newspapers. And mind it, the reputation of Apple company, how much it will be tarnished. We should not say that, but sometimes we have to. Then they said, all right, sir, then from Bangalore somebody came and this thing, that thing. That's how it happened. You people, corporate sector, will be the best persons, according to me, who can make use of this mediation method. Because it saves a lot of, not only money, your manpower. If you send your executive to the court, you know how much time he has to spend? Whole day. He has to come in the morning, sit in the court till evening, and in the evening he used to go away saying that the case has not been taken up. So all these things are there. Oh, the best course open is try to resort to this mediation. Institutions are there. You can approach them and try to solve your disputes and get the best result out of it without there being any problem for you.
So I want to ask that as a law student, can we choose mediation as a specific law career in future?
If you choose mediation as a career where you are trying to represent your client's case and see that he gets a solution, you are doing the legal side of presenting the case as an advocate to the mediator and getting a solution. The second side of it. You personally want to be a mediator. Now the challenge you have is whether a 60-year-old person who has been in business for 30 years prefers a 25 years aged person as a mediator. Now here the challenge is the 25-year person should be enough mature to understand 30 years of business emotion, which becomes difficult. So if you are choosing your career as a mediator, it's good to complete a certificate. It's good to get yourself accredited mediator certified. But then believe that this certificate will be useful to you 30 years from the date on which you get it. Because you should add value to it by the experience which you have acquired. To present a case as a mediator, as an MSME, I can present. As an advocate, you can present it better. So that's where your choice and your preference as a career will come.
One thing I would like to tell you, rest all professions have adopted the latest amendments or latest way of their profession. But legal profession is the only profession in the world which is adopting the latest technologies and methods, but it is holding its ground to the almost centuries old traditions. Even today, a 5 days senior to me will be senior in my practice.
True.
We bow and salute our seniors. That practice even prevails and that matters to us. So with all proud, I can say, we represent the culture of India.
Even for being a mediator, there's some requisites are there. So career-wise, it will not be helpful to you. It's a kind of social service you can take it.
In my own case, where some property dispute is going on, I advised my advocate, why can't you talk to our opposite advocate, let us discuss and try to resolve something. Then they said, no, sir, you should not do it.
If your advocate is not doing this job, then choose somebody else, a good friend or a family member or anybody. Ever lekapothe gullo pantul nadagandi sir, ఆయన చేసి పెడతాడు.
How can you present it to the international business? The disputes happen in the international trade.
Mediation framework exists for international laws also. So in the agreements, in the agreements, a dispute resolution clause will be there, wherein they will be mentioning what is the seat and where there's a probability of mediation. We can initiate mediation.